All right, counsel, I am going to tell you again. Only one person can talk at a time. And Mr. Gray, you've got to let him finish his answer before you start interrupting him.
Can you instruct him if the answer calls for yes or no to say yes or no?
I'm not going to tell him to say yes or no if he can't answer with a yes or a no. But I think we got it. Our poor court reporter has a really hard job, and let's not make it harder for her. Okay? All right, you ready for the... Thank you. You can have a seat. All right, thanks, Jeffrey. Okay, please be seated. Mr. Gray, you may continue.
Thank you. Thank you, Ron. Mr. Stoughton, I'm going to ask you a couple of questions about your CV, your curriculum vitae, and you have one on page 6. You have it titled Selected Expert Consulting Reports, Depositions, and Trials. And most of the listed selected expert consulting matters are civil. Is that a fair statement?
Yes.
And these civil cases that you are a consultant on, or sometimes testify and sometimes give a deposition, the civil cases are 1983 actions, correct? Most of them?
1983 or state tort suits, yes. Or a combination of the two.
Okay, and a 1983 action is an action where a law enforcement officer, or maybe the city that he works for also, are sued for unreasonable force. Their statement?
Some of them are alleged excessive force cases. Some of them are other Fourth Amendment violations like unlawful search, unlawful arrest. Some of them are, it's a range, but they are allegations of constitutional violations generally.
And what happens in those cases is an individual, a plaintiff, sues the police officer and maybe the city under Bivens versus United States, correct?
Not under Bivens. Bivens is a federal action, so it would be under Monell.
Okay, but federal actions would be under Bivens.
A lawsuit against a federal agent or federal officer would be a Bivens action. A 1983 suit is against a state or local officer.
All right, I'm not going to take issue with you on that. The fact is that you've assisted on, I counted here about 30 cases involving plaintiffs suing law enforcement officers. Is that about accurate?
It's.
On the CV.
I'm sorry. Are you asking me whether it's accurate on the CV or accurate as to what I've done?
The CV that I received, I'm asking you.
Yeah, that sounds about right as far as listings on the CV. Sure.
And it is true, is it not, that of these 30 cases you cite, I counted 27, but take my miscount off and call it 25. That of the 30, 25 of those were either you testifying as an expert for the plaintiff, which would be the person suing the cops or the city, or taking a deposition or assisting the plaintiff in suing law enforcement. Fair statement?
I would not describe that what I'm doing is assisting the plaintiff. I am reviewing a case file and rendering an opinion.
And you're doing that for the plaintiff, right?
I am hired by plaintiff's counsel to review the case and render an opinion.
And once you render that opinion, if you believe that there's a violation of the individual's constitutional rights, you tell the lawyer, right?
So my opinions in those cases still apply the professional standard. I'm not testifying that there was a Fourth Amendment violation in most cases. What I'm saying is an officer's actions are or are not consistent with generally accepted practices.
Okay. And you're hired by the plaintiff in 27 of those 30. Is that right?
The CV has maybe half of my total retentions. So of the ones on my CV, I would have to count them up. I haven't done so, but that could be right.
Would you say that you're hired by the plaintiff in more cases than are in here, in the CV?
Numerically or proportionally?
By the number, are there more than 27?
Yes.
Okay. You also have written about police body-worn cameras. Actually, you wrote a North Carolina law review, and I believe it was in 2018, about body-worn cameras, correct?
Yes.
And I quote you in this body-worn camera article, Limits of Human Interpretation, page 1405.
The objection?
Proper form of cross-examination.
The objection is overruled.
You write in the law review, the potential for body-worn cameras to have informational benefits assumes that viewers will be able to accurately interpret the recorded videos, but just as digital cameras have inherent limitations, so too do their users. We all suffer from a range of cognitive limitations that can affect our ability to interpret evidence, including video footage. Is that what you wrote?
I don't recall the exact wording, but it certainly sounds like what I wrote.
Would you take issue? I can show it to you.
No, I accept it. It is definitely the point that I was making, and I will accept your representation that is accurate.
Then on
the
the
wording
next
I used.
page, you write, one such cognitive bias is motivated reasoning, defined as a tendency of people to conform their assessments of information to some goal or end other than accuracy. Did you write that?
Same point, yes, or at least certainly words to that effect, and I accept your representation that that's what I wrote.
Relatedly, the tendency to interpret information in a way that confirms one's pre-existing worldview or beliefs that Cahan calls identity affirmation or identity protective cognition also affects the way we see the world. Did you write that?
Yes, Kahan, yes.
So what you're saying here is that the body-worn cameras informational benefits assumes that viewers will be able to accurately interpret the recorded videos. But just as digital cameras have inherent limitations, so do their users, correct?
Yes, absolutely. A great deal of the body-worn camera training that I do is on interpreting body-worn camera footage for exactly those reasons.
And what you did in this case is interpret body-worn cameras, correct?
I would say I interpreted body-worn camera footage in the compilation of an entire set of evidence. Certainly,
Okay.
body-worn camera footage is included in the body of evidence, but it's not.
You interpreted body-worn cameras, and you also read the police reports in this case?
Police reports, about 6,000 or so pages of documentation, interviews, dash cam or squad cam footage, yes.
And you also, did you know about Sergeant Johnson's testimony in this case?
Yes, I also reviewed some of the testimony in the case, including most of Sergeant Johnson's.
And the opinions you wrote were prior to Sergeant Johnson's testimony. Fair statement?
Oh, absolutely. Yes, I wrote the report prior to his testimony.
Thank you, sir.
Thank you.
Thank you, Your Honor. Professor Stoughton, I think I'll be brief. You were asked about this article you wrote in 2018 about body-worn cameras. You recall that testimony?
Yes.
And
Excuse me.
And during direct examination, I asked you about some of your work with body-worn cameras. You talked a little bit about that. Was that paper you wrote part of your answer, what you were telling us that you have done with regard to body-worn cameras?
Yes, that's part of the body of work. I focused on body-worn camera footage and its interpretation.
And Mr. Gray read to you a couple of quotes from your article about the potential for body-worn cameras to have benefits and limitations.
Yes, that's correct.
That was, I think, the essence of the first part you read?
Yes, the idea that that getting the most information out of body-worn cameras is limited by the first clause. There was some of the limitations of the technology itself, which I talk about in a previous section of the article, and then that section is about human interpretation of camera footage.
And the second part that he read to you was about, my understanding, some kind of cognitive bias, correct?
Yes, a particular type of cognitive bias that affects human ability to interpret information.
And so you are aware of that, have studied that?
Yes.
Did you, when you were creating your opinions in this case, were you careful to avoid any cognitive biases regarding the body-worn camera video?
To the maximum extent possible, absolutely.
You were asked about the different versions of the taser from the X26P to the taser 7. Do you recall that, being asked about that?
I do, yes.
Your Honor, may I approach to retrieve Exhibit 203?
Yes, you may.
And Professor Stoughton, I will represent to you that Exhibit 203 has been previously received in evidence as the taser that Ms. Potter wore on the day of this incident. And, Your Honor, if I may approach, I'd like to have the witness explain what he understands the difference in the coloring of the two models.
You may approach.
Thank you. And I'd like to first, for the record and for everybody in the courtroom, the battery has been removed from that taser, correct?
It has, yes.
So it's incapable of firing?
Yes, and yes, that's correct.
So, and if you could just point out to the jury the differences in the two, just trying to remember to stay close enough to the microphone to be heard.
Sure. So the Taser X26P, as I recall, has two different coloration patterns. It has an all-black model, and there is, I believe, an all-yellow model where the entire top is yellow. This is the X7 where, except for this strip, the handle is black, and then the top of the Taser is half yellow, half black. The sides, as you can see, are predominantly yellow, but for the release switches there.
And then I would like to show you Exhibit 13, and I would ask that it go, that's the body-worn camera of Ms. Potter, and ask you to go to 20156, please. And while Mr. Miller is doing that, Your Honor, may I approach the witness to retrieve the exhibit?
Yes.
Do you see that portion of Exhibit 13 on the screen in front of you?
I do, yes.
And for the record, it does, the timestamp reflects 20156. Would the yellow markings on Exhibit 203, Officer Potter's taser, have been visible if it had been in Ms. Potter's hand rather than her Glock?
Yes, had the firearm been a taser, the yellow markings would have been very clearly distinguishable on this picture.
You were asked about the interaction between Mr. Wright and the officers, Lucky and Johnson. And the word I believe that Mr. Gray used was fighting. Do you recall him asking you those questions?
Yes.
Was there a time when Mr. Wright was compliant?
There was a time when Mr. Wright was compliant prior to pulling away from Officer Lucky's attempt to handcuff him, yes.
And then after that, did you see any evidence that Mr. Wright was assaulting the officers?
No, the evidence, both in the material I reviewed as well as the testimony, suggests he was not aggressive or assaultive in the sense of, for example, trying to strike the officers or retrieve a weapon or the like.
But he was trying to get away.
Yes.
So is the word fighting one that you would use to characterize Mr. Wright's behavior?
I can understand how that word would be used casually. It's not the word that I would use.
What word would you use?
You could use resisting, actively resisting, even struggling. Fighting, I think, for me at least, connotes a degree of aggression or assaultive behavior that is lacking in this case.
Mr. Gray asked you if you would agree that if Mr. Wright hadn't decided to be non-compliant and pull away from the officers, none of this would have happened. Do you recall that question?
I do.
When, based on your training and experience in this field, once an individual attempts to pull away from the officers, are the officers still required to use reasonable force?
They are. The idea that merely because someone resists an officer sort of allows officers to do anything at all is one of the points that we talk about in the book. Should be a two-staged question. First, did the individual resist in a way that justified some use of force? And then if so, how much, what type of force, how severe is the force that officers could use in that particular circumstances? So the fact that someone is resisting can certainly justify some force, but does not allow officers to use any amount of force in response.
And you were asked about your incidents when you were working as a police officer. Do you recall being questioned about that?
I do.
And you were asked if, when you got into incidents, whether your adrenaline started pumping.
Yes.
And I think you said that, colloquially or casually, one way of saying it?
Sure, yes. Yes.
Based on your training and experience in the field that you currently work in, Professor Stoughton, when an officer gets into those situations and, to use the phrase, the adrenaline starts pumping, are they still required to use reasonable force?
Absolutely.
When you were working as a police officer, did you have to, when you started a shift or went to work, have to think about being able to act reasonably as a police officer.
Object, Your Honor, it's outside the scope of my cross-examination.
The objection is overruled. You may answer.
Yes. Prior to every shift that I worked, it was my habit as I was putting on my vest, as I was strapping on my gun belt, to review my equipment to make sure that I was emotionally, I suppose we would say now, emotionally in a position to do my job.
That's all I have, Your Honor, and if I may approach the bench to return the exhibit.
Yes. Mr. Gray?
Yes, just a couple. Mr. Stoughton, you do agree on that video, you do agree that when Mr. Wright broke away from attempting to be handcuffed, that he tried to get into the car, got in the car, and if the officers had let him go, he would have taken off in that car. Is that right?
Yeah,
I'll let the answer stand.
I think that's the logical conclusion of what he was trying to do, yes.
Yes. And if he had taken off in that car because the officers were there, not in their car, they were standing out in the street, you would logically conclude that he'd take off quite fast, correct?
I don't think there's enough information to say their low-speed flight is not uncommon in vehicles.
Usually when somebody takes off from 3 officers in 2 squad cars, you drive slowly.
I'd say it's not uncommon for someone to flee a traffic stop at low rates of speed or high rates of speed.
They're both the same. Is that what you're saying?
No, they're different rates of speed.
Okay. Well, so wouldn't it be reasonable for a person fleeing from the law enforcement officers, 3 of them, 2 squads, to leave in a fast manner?
I don't think it's particularly reasonable to flee from an arrest.
Would it be reasonable to flee if you're stoned on marijuana? He would,
The objection is overruled. You may answer.
you were aware, were you not, based on you knew the testimony here, that the autopsy witness said that he had a high rate of marijuana. Were you aware of that?
I am aware of that. It didn't factor into my analysis because it wasn't information available to the reasonable officer at the time.
But you would agree, would you not, that it would be a danger to the public to have somebody driving a vehicle high on marijuana? Fair statement.
Objection, Your Honor, relevance.
Yes, the objection is sustained.
Okay, sure. That's all I have. Thank you.
Mr. Frank, any redirect?
Nothing further, Your Honor, thank you.
Okay. You may step down.
Thank you.
The state may call its next witness.
Thank you, Your Honor. The state calls Arbuey Wright.
Do we have a standing objection?
Yes. Okay, Mr. Wright, please come forward and stand behind the witness chair right next to me. And will you please raise your right hand? Do you swear under penalty of perjury that you will truthfully testify in connection with this trial? All right, you may take a seat. And could you please remove your mask? State your full name and spell it.
Arbuey Wright, A-R-B-U-E-Y. Last name is Wright, W-R-I-G-H-T.
Okay, Mr. Wright, a couple things to keep in mind when you're testifying. The court reporter is taking down everything that's being said, so you have to answer orally instead of shaking your head. And please don't say uh-huh and uh-huh and uh-uh, because that doesn't come out on the record. Also, if you don't understand the question, please let the questioning lawyer know and it will be clarified. If an objection is made, you need to stop talking immediately and not answer the question unless I tell you to do so. All right?
Yes, ma'am.
And only one person can talk at a time because the court reporter can't take down two people talking at the same time. Wait until the question is finished before you start answering.
Okay.
All right. Counsel?
Thank you, Your Honor. Good afternoon, Mr. Wright.
Good afternoon.
I'm going to ask you some questions just about who you are and have you introduce yourself so the jury can learn a little bit about you, okay?
Okay.
How old are you, sir?
42.
And what city do you live in?
Minneapolis.
How far did you go in school?
12th grade.
And are you working now?
Currently not.
And are you married?
Yes.
Who are you married to?
Katie Wright.
And does Katie Wright also go by her legal name, Katie Bryant?
Yes.
Do you and Katie have any children together?
We have 3.
And could you tell the jury their names, please?
Daunte Wright, Destiny Wright, and Diamond Wright.
And is Daunte, your son Daunte, is he no longer with us?
No.
Was Daunte the oldest of the 3 children?
Yes, he was our firstborn.
What was Daunte's role as the older brother to 2 younger girls?
His role to the younger girls was the big brother, to look after them, watch after them.
And what was his relationship like with his younger sisters growing up?
The relationship with the younger sisters was like a big brother. Joked a lot, always constantly following behind them, making sure they were okay.
And did you and your wife, Katie, and your children, Daunte and Diamond and Destiny, all live together up until Dante's death?
Yes, we did.
Do you also have some other children from a previous relationship?
I do.
And how many other children do you have?
I have 2 other kids prior to our relationship, Marcus Wright and Monica Wright.
And where do Marcus and Monica live?
They live in North Carolina.
So between you and your wife, Katie, how many children do you have altogether?
She had 2 kids prior to our relationship, so we had 7 altogether.
So getting back to your life with Daunte growing up and his younger sisters, what kinds of things did you and your family do together for fun to pass the time?
Well, we got together every Sunday we would have cookouts and stuff like that. Family days, we would do movies and stuff like that. We did a lot of things as a family, as a group, because we're like all we have, so.
Cookouts, he said?
Cookouts constantly every Sunday, every weekend, pretty much.
Did Daunte have any favorite foods?
Well, yeah, he did. He liked chicken, I guess. We all did. So,
Was that a family favorite at the cookouts?
excuse me?
Was chicken a family favorite at the cookouts?
Oh, yeah. Yes.
Did he like sports?
He loved basketball. He played pretty well. He was a left-hander, so he was pretty good.
And as he grew older, into his teenage years and beyond, did he have a variety of different jobs that he worked?
Had a lot of different jobs. I even got him a job with me before.
And when you say you got him a job, was there a time where you and Daunte worked together?
Yeah, it was the time we worked together. I was his boss, and I was happy, to have my son coming on to work with me.
Where was it that you two were working together?
I was a manager at Famous Footwear.
And about how long did you two work together at Famous Footwear?
About a year. He worked there about a year with me.
About how long was that before he died that you two worked together?
Well, it was his last day was when the COVID hit. So his last day working with me was right in the beginning of the COVID.
So about a year ago is when you
Yeah.
guys stopped working together? How was it for you working with your son, Daunte?
It was great. It was challenging, to work with my son. I tried to let him understand the difference between where at work I'm your boss and at home I'm your dad. It's a difference. So, but it was funny. Like, it was this one time where I had sent him home because he was on his phone at work and he wasn't supposed to be on the phone at work. Like, yo, we gotta go home. And so he went and asked my boss, is it okay if my dad sends me home? And I'm like, my boss like, yeah, he's your boss. And I'm like, well, you need to go home. And I come out in the hallway and he's still there. And I'm like, well, why are you still here? And he's like, well, Dad, I rode with you. I couldn't go home because you're my ride. I think it's funny, but yeah, that was a funny thing that happened at work.
So not only were you working together, but you were driving to and from
Yeah,
work together?
every day, yeah.
You got to spend some quality time together.
Yep, spent a lot of time together.
Your Honor, at this time I'd offer Exhibit 240.
Any objection to 240? Okay, I previously ruled on it over defense objection, and 240 will be admitted into evidence.
Thank you. If we could publish it, please, and put it on the screen. All right, there's a picture on the screen now. It's Exhibit 240. Could you just explain to the jury what's shown in this picture? Take a minute if you need one.
Picture of me and Daunte. You see how, I was holding him. See how his arm, we had a close relationship. He was me and my wife's first child.
And was this picture at your home?
Yes.
Was this not long before he passed away?
This was right before he passed away.
And if we could put on the screen Exhibit 3, please. That's already been admitted. Did your son Daunte also have a son of his own?
Yes.
And
First and only child. That's my grandson, Daunte Jr.
And your grandson's name, you said, is Daunte Jr.?
Yes.
How was it seeing your son Daunte as a father?
Excuse me.
How was it to see your son as a father?
Man, to see him as a father, it was like I was so happy for him because he was so happy. He was so happy about Junior. And this was my chance to be a grandfather.
Did they have a close relationship?
Yes.
And did Daunte Jr. spend a lot of time with your family as well?
Yeah. Daunte Jr., Daunte lived with us. Junior was pretty much there every day. And he loved his son.
And do you love your son, Daunte, a lot as well?
A lot. I loved Daunte. He was loved.
Do you miss him?
I miss him a lot every day.
Thank you, Your Honor. Nothing further.
Is there any cross? All right. Thank you, Mr. Wright. You may step down. Does the state have any further witnesses? All right, members of the jury, we're going to stop right now, and I'm going to let you go home, but I want to remind you, just and I've told you this before, I don't mean to insult you, but it's very, very important that you not listen to any news reports about this case. Don't read any articles. Don't, any podcasts. Don't do any research on the case. And stay off social media about this case, okay? Now, I heard that we might be having some bad weather tonight. And tomorrow the roads may be a little icy, so I do want to start on time tomorrow at 9 o'clock. So please take that into consideration, the fact that it might take you longer to get places tomorrow morning, okay? All right. Have a nice night, and we'll see you, and drive safely tomorrow morning, okay?